All right, good morning, everyone. This is the staff attorney for Judge Kraus. The judge will be joining us momentarily. We have a short calendar today. Mr. Clark, I want to apologize. I was unable to check my emails after 3:30 yesterday. So I know you had a request in to be excused, and I was only able to relay that to the judge this morning. So my guess is she will make quick work of your case, but thank you for appearing. Uh, and I wish you didn't have to have appeared.
Oh,
All
no
right,
problem.
okay. Well, here's the judge, and we'll get underway.
Good morning. Okay, I have a few, not many matters. Hopefully we'll get through them pretty quickly. Right now I'm just calling the calendar to see who's here and what all we have to deal with, and then we'll get into the meat of whatever we have. Greatwood Glen versus Cordetta Spells.
Craig Cooper here for Graywood Glen, and I also have Miss Jennifer Mortimer here, who's a representative of the client.
Okay, and okay, thank you. Mr. Freehoff, I saw that we had heard from Ms. Spells by email. I was expecting her to be here. Have we not seen her this morning?
Yes, Judge, as you know, she appeared at our last default calendar where
Right.
we got her email address from her. I then sent the reset notice to her and opposing counsel. She contacted us yesterday. I responded to her this morning, sending her the notice again that has the invite information telling her she was to appear this morning.
Okay.
So I do
Well,
not know
we'll
why
wait
she
and
has
see.
not
We'll
appeared.
wait and see if she does. Thank you. Lakeside Preserve Homeowners Association versus Kendall Lodge.
Good morning, Your Honor. Darylyn Hughes here for the plaintiff.
Hi, Ms. Hughes.
Oh, wow. I do also have a witness if needed to support damages, Teresita Leak.
Okay. Oh, perfect timing, Miss Leak. Okay, thank you. And obviously, I understand this is a default matter. So I understand I wouldn't necessarily expect, is it Mr. or Ms. Lodge to appear? Do we know? Anyway, I was not expecting that person, but have you been in contact with that person? Was there any expectation that they might appear?
I had heard from them. I was hoping that they would appear because they actually asked about a payment plan, but they never signed the agreement. So if they appeared, I was just going to have them sign that here, but looks like they haven't appeared. If you'd like to take our matter a little bit later to give them additional time, we can, but we're ready to proceed immediately as well.
Okay, thank you. Cascade Cove versus Tatum Roberts.
Good morning, Your Honor. Attorney Danielle Burnett here on behalf of the plaintiff.
Hi, Ms. Burnett. And same question. I understand it's a default matter, but have you had any contact or were you expecting Tatum Roberts to appear?
She's actually present on the Zoom.
I see Ms. Roberts. Thank you. Okay. Thank you very much, Ms. Burnett. And Prime Development Group versus John Clark. I'm sorry. No, not versus John Clark. Prime Development Group versus Ian Smith, Mia Beasley, etc.
Good morning, Judge. John Clark for Prime Development.
Hi, Mr. Clark. And who do I have, if anyone, on behalf of the defendants? My review of, and this actually leads me to my main question for you, Mr. Clark. I've seen your proposed order. Everything appears to be in order. One of the things I was not clear on, and not because of anything you did not provide, but because of the nature of the relief requested, is it its own relief or is it still functionally a default hearing in the sense that my review of the file indicates that everyone was properly served and that none of these individuals have asserted any objection to the requested equitable partition?
Right. If I understand your question, we're just asking for an order for the partition to go forward. It's not really a default judgment in the sense of damages or anything, but for the relief sought, it's not opposed.
Right. And I guess that's really my question is, I know default is a legal term of art, but is it still, whatever the relief is I'm granting you, is it still functionally a default judgment because no one answered and said, no, they can't have this, or no, I object to this, or yes, I agree to it? That's what I was trying to figure out. I don't know that it matters in terms of the ultimate relief you get, which is the order granting your right to equitable partition. I just was curious.
To the extent I can answer, I think it is. I mean, they've admitted all the relief that we've
Right.
asked for. So it's essentially default. Yes.
Yeah, and that's the reason I asked is that I typically, whatever the relief is, I typically like my default judgments to say that all the people were served and they failed to answer and therefore they are in default. Now, whether I call it a default judgment or call it an order granting equitable petition, I don't know that it matters. I just wanted to know what your thoughts were on that issue. So I appreciate that, Mr. Clark. And then Prime Development Group versus Pat Labatt, and regarding, I'm sorry, I don't know the property address, but who do I have here on that matter?
We have a consent on that, Judge. I believe Ms. Keeley and Mr. Caskey.
Yeah, I just saw that this morning.
Honor.
Mr.
Sorry,
Yes,
Your Honor. Chris Reading appearing for Shannon Villas Condominium Association.
okay. And Ms. Keeley, are you here on behalf of Fulton County Tax Commissioner?
Yes, Your Honor, I am.
And Mr. Caskey, are you here on behalf of who are you here on behalf of? Sir?
The sheriff, yes, Your Honor.
Okay. Thank you. Okay, and I just received that order this morning, so I haven't really had a chance to look at it in great detail. Is it it looks like it resolves the entirety of the funds. And then I had a question for you fine folks who do the interpleters. I was reviewing a couple of interpleters recently where I had received a request, after the fact for a stakeholder to obtain the funds that were held in the registry of the court, the remainder funds after everybody did their consent order. And one of the things I noticed is that even though my orders are standard and they always say pay the money in, and then the clerk pays the lawyer, and then the clerk pays the interest holders the amounts. What I noticed in that case, the only payment was to be made to the sheriff's department attorney. What I noticed was that what happened, I mean, I used to litigate interpleters, and not these kind, insurance kind, but what we did is we never actually gave the money to the registry of the court and then had them give us our fees back. We just took our fees out and gave the registry the remainder. And in the 3 or 4 cases I looked at, that seems to be what's happening, which is fine with me. I don't have any objection to that, Mr. Caskey. I just was curious, is that standard practice? And if it is, why don't we make my order reflect that is standard practice that just authorizes the sheriff to retain those fees and then pay the remainder into the registry?
Well, my understanding is from an accounting perspective at the county, they would much prefer just pay everything in one fell
Well,
swoop.
that makes sense, except that in at least 3 of the cases I've seen, they didn't do that. What happened is the remainder amount after the award of fees. So say, the attorney, there was 35 grand, the attorneys were entitled to 4 grand. The only amount of money that got paid into the registry was about $31,000, at least 2 of them that I looked at.
Okay.
And so my question is that not how we should be doing it? And so I should follow up with the clerk to make sure they're doing it the way my order says, or should we look at a different procedure?
My understanding is the procedure is, every directive I've gotten, and I think we've done several hundred of these, is
$1 million? Yeah.
I think is that if it's $35,000, the sheriff's going to make 1 check, deposit that in the registry, and then it's up for the judge to decide how to disperse it. They don't want to be in a position of holding money back and doing this entry, that entry.
That makes complete sense to me. I just stumbled across that one. Because you guys do this all the time, I wanted to follow up with you about what your experiences have been, so I can follow up and make sure that the orders that I'm drafting accurately reflect what's really happening in the world and what should happen, and then follow up with the clerk if there's an issue with it not happening occasionally.
Your Honor,
Yes.
were those all from the same attorney? Do you recall?
I need to go back and look because, of course, it wasn't necessarily from the same attorney, but it was the sheriff.
Right.
When they paid in the funds, they were paying in an amount that was less than the funds retained by the attorney. So, like I said, I'll look into it again. I just wanted to ask because y'all do this all the time. So, so to that end, I did receive the order. A brief glance at it looks as if the parties have agreed that the amount of, let's see, $41,408.48 is going to go into the registry. The sheriff is going to retain $3,838.23. The Fulton Tax Commissioner will get $997.72. The Shannon Villas Condominium Association will get $20,169.66. And it looks like the remaining full balance of $16,402.87 would go to the Clark Group on behalf of Prime Development. Is that what everybody understands and intended to include in the consent order that was submitted to me?
Yes, Your Honor.
Your Honor.
Yes, Your Honor.
Yes. Okay. Well, in that case, your order appears to be in good shape, and I will go ahead and sign it and get it on file, and y'all can take care of that. Anything else that any of y'all need from me, Mr. Caskey,
No, Your Honor.
Mr. Redding,
No, Your Honor.
Ms. Keeley,
No, Your Honor.
Mr. Clark?
Not on this one, but I
Right.
wasn't sure whether you needed me on the first case still to stay on the call.
Right. I'm going to go back to that in just a moment. But for now, those of you who are here just on that Prime Development interpleader case that we were just discussing, that consent order is fine and y'all can all be excused.
Thank you, Your Honor.
Thank you all. Have a good day.
Thank
You
you.
too.
Okay. And then Mr. Clark, circling back to you, I have reviewed your the proposed order that was submitted, Mr. Clark, and hang on one second. My review indicated that, and this is why I asked, because the order that you sent, I added briefly some language regarding the proper service of the individuals. It was in various forms. Some were personally served, Secretary of State, publication. But I did add in the record reflects that the petitioner properly served the respondents, and that no respondent has filed an answer or objected to the equitable partition. And then other than that, I granted the order essentially as it was presented with the relief requested. And so everything appears to me to be in order, and I'll go ahead and get it on file for you, Mr. Clark.
Thank you, Judge.
Okay, thank you. Have a good day. Okay. Excuse me. Now, going back to the beginning. Craig Cooper, I have you here. Have I seen or heard from Ms. Spells? Okay. So Mr. Cooper?
Yes, Your Honor.
Okay. I have also reviewed the order that you presented. And let me make sure I'm looking at the right one. The reason I'm going to mention it and mention that we were in touch. Somebody, Ms. Mortimer, can you mute the line until I need to ask you questions? Because I'm getting a weird audio feedback and I don't know if it's you. Thank you. I reviewed your order, Mr. Cooper, and the only reason everything in your order appeared to be fine. My review of the record indicated that defendant was served on November the 3rd, but proof of service wasn't filed until December the 9th. And therefore, nope, I'm looking at the wrong one. I'm sorry. Hang on. I want to make sure I have the right. I apologize. My review indicates that the defendant was served on November the 14th, and then proof was filed very quickly, and therefore the defendant had until December the 14th, and that more than 15 days have passed since then, and no answer has been filed. And then you had requested a final default money judgment in the amount of $9,609.45. The two things I wanted to touch base with you. One, I need you to present that evidence. I wanted to start by telling you I'm aware of the default dates. I agree with you that there is a default, and so the issue for this hearing is those damages. But I did want to mention to you that Ms. Spells she appeared at the hearing last week, which had been reset unbeknownst to her. We did get, as you heard Mr. Freehoff say, an email address from her, and she has been using her email to send Mr. Freehoff documents, some of which were copied on you. And in full disclosure, I've not reviewed any of the matters that she sent ex parte, but some communications have been sent directly to Mr. Freehoff ex parte. The part that I gathered from the part that was communicated to everyone and what she said to me at the hearing last week is that on January the 20th, she had made a payment in the neighborhood of about $4,700. And she, of course, thought that resolved this matter entirely. Now, I understand that when it gets to this point, that might have been the debt that she had, but that there are other things, including attorney's fees and interest and other matters that go with it, and that that's likely what is making the amount of fees or the amount of the judgment, her payment not resolve that judgment. But I wanted to make you aware that we have had that communication from her and that she had made sure to communicate with us that she had made that payment, confirm that y'all received it and were understanding and crediting that payment. And if that's a legitimate, all that stuff is right, does that change the nature of the judgment that's being requested, et cetera? So if you could take that from there, Mr. Cooper, I would appreciate it.
Yes, Your Honor. If I would like to clarify that point, the payment first, if you don't mind. My client is a sub-association of a master association. So Windermere is the master association. Ms. Spells is responsible. We don't represent anymore. We don't represent the master association. So I have limited knowledge over her account with them, aside from communications I've had with the firm that does represent the master association.
And I think the representation was made that the payment was made to the firm. I don't have any reason to, the only information I have is the representation from Ms. Spells that this payment was made. I'm just giving you the information that I have.
So from what I understand, and she's provided a receipt to this, to our office to this end, but from what I understand, Ms. Spells also has a open and pending lawsuit as a defendant where the master association, which is unrelated for these purposes to my client, they have a pending lawsuit with her, and she paid the law firm that represents the master association on that account.
Okay.
We received a correspondence from their office letting us know that they did receive the funds that she represents in the emails. And it was, from what I understand, it was credited to that account.
Okay.
But that payment, aside from, for these purposes, we believe that payment's irrelevant for this account. And aside from that payment, we have not received payment, nor has my client, since the complaint was filed.
Okay. And fair enough. I'm happy to, I don't have any concerns accepting your representation about the best information that you have. It's just, I wanted to make sure that we at least had that discussion. And I think I understand what you're saying is that there is another, it's unhelpful, at least to my way of thinking, that it's a master and a sub here, but at least it's a separate matter that she owed funds to the master association, and that the payment that she's representing that was made to that master association for some matter unrelated to this claim for unpaid assessments relative to Greatwood Glen. Is that right?
That's correct. Yeah.
Okay. So with that understanding, we'll go back to what I originally said, which is I've reviewed the file. It does appear that, in fact, there is a default and that a default judgment is appropriate. No effort has been made to open the default. And so the issue is one of damages. So now, Mr. Cooper, in a more straightforward manner, if you want to take it from there, sir.
Yes, right. And if you like, I can provide testimony as to the attorney's fees to liquidate those damages. And Your Honor, as on the statement that we provided for fees, Miss Victoria Sands handled the majority of the work done in this case. She is out of town on a conference, a CLE, but I've spoken with her prior to this, and I'm familiar with all the facts in the case and everything we've done on it. So I am authorized to speak on that, and I will testify as to that. My name is Craig Cooper. I'm an attorney authorized to practice law in the state of Georgia and have been since 2013, associated with the firm of Nowak Howard. My hourly rate as a senior associate at the firm per retainer client, such as the plaintiff, is $325 an hour. Nowak Howard has performed services on behalf of Greatwood Glen HOA in the collection of unpaid assessments and related fees and charges. from the defendant in this matter. On behalf of the association, Novak Howard send the defendant notice of the debt, the association's intent to collect, and its intention to pursue the lawsuit. A lawsuit was filed on March 2024. Service was attempted and it was unsuccessful given the defendant's living in multiple locations. At the time, she was in California. So that case was dismissed. We filed a second case, which is the instant case, perfected service, and prepared a motion for default judgment, which is the subject of today's hearing. The legal services described, not including the fees for today's hearing, resulted in an expense to the association of $3,555 in legal fees, $673.71 in expenses, plus $250.02 in court cost. I have an itemized attorney fee statement, which I can pull up if you like. I could share my screen to provide that.
Thank you.
One moment. Your Honor, are you able to see the?
I am, thank you.
And so these amounts are, this is an itemized statement, a breakdown for all of our fees and expenses in this matter. There's the first page is fees, the second one is expenses. This provides for a full accounting of the amounts applied to the defendant's account. These amounts are detailed in the attorney fee statement for this matter. This statement is a business record for the firm, and it's within the regular course of business for the firm to make and keep such records. The entries appeared on the statement are made at or near the time they are incurred, made by or from information transmitted by someone with personal knowledge and a business duty to report, and subsequently reviewed for accuracy. The hourly rates were performed and time spent for the legal services rendered in connection with the case are reasonable, usual, and customary in light of the nature and complexity of the work, and were actually incurred and are either paid for or are currently being billed to the association. I would just ask the court grant an additional hour time for my preparation and appearance at today's hearing, which I believe I've anticipated and incorporated in that proposed order.
It is. Yes, sir. Okay. You can take down your screen share, Mr. Cooper.
Fine.
Okay, so as I said, the record indicates that Ms. Spells is in default, and that the amounts sought for assessments and interest due and owing under the declaration are liquidated damages that have been represented to the court and demonstrated, and that to the extent there are unliquidated damages, I've received the testimony of Mr. Cooper regarding the attorney's fees that were incurred by the association. And that would be principal in the amount of $4,368, interest in the amount of $505.04, attorney's fees in the amount of $3,555, plus an additional $325, which is the hour for Mr. Cooper's preparation and then appearance here. Collection costs in the amount of $673.71, and court costs in the amount of $250.02, for a total judgment amount of $9,609.45. Is that correct, Mr. Cooper?
That's correct, Your Honor.
Okay. So I have received your order. It will be finalized today, and we will get it on file for you, and then you can go forward from there.
Thank you very much. I hope you enjoy the rest of your day. May I be excused?
Yes, thank you, Mr. Cooper. Nice to meet you, Ms. Mortimer. Have a good day.
Take care.
Okay, next up is going to be Lakeside Preserve versus Kendall Lodge. Ms. Hughes, that's the one that I was mistakenly rattling off the dates. I have received your order. I've reviewed the file, and it does appear that the complaint was served on November the 3rd, but proof of service wasn't filed until the 9th of December. So that meant that the defendant Lodge had until January the 8th to answer the complaint. So full disclosure, the deadline to open default as a matter of right is actually today. And so to the extent that your whatever you provide to me in support of your default judgment is satisfactory, I will not enter any such order until tomorrow. In the event that perhaps Mr. Lodge or Ms. Lodge, I don't know, comes forward and pays costs and notices the intention to open default as a matter of right, which, as I said, they have until today to do, because by my math, if the answer was due on January the 8th, the 15th day after that, I think, would be, well, maybe I'm doing my math wrong, but in any event, we're going to wait until tomorrow just to be on the safe side, but you'll have it tomorrow, assuming everything is in order.
Understood. That makes sense. I agree.
Right. So why don't you take it from there, Ms. Hughes?
Yes, so like you said, this is a default matter. I think you may have already entered an order as to liability. So, Ms. Leek, I'd like to swear you in. I did file a notice of intention to submit the ledger into the record without a live testimony, and there were no objections.
That's correct.
So do you still want me to have?
No, as long as I have, my understanding of the obligation here is that to the extent that you have prayed for and asked for the unpaid assessments that were due and owing, that those matters are liquidated in the sense that even if you don't have a specific dollar amount because it continues to run, that those amounts are functionally liquidated, and that the one unliquidated portion, and really, if you're getting the fees pursuant to the declaration, there's an argument to be made that those are even liquidated. But either way, I have some evidence regarding an understanding of liquidated-ish amounts of assessments that were owed. And what I need from you is a representation regarding the amount of attorney's fees that are being sought.
So my name is Darylyn Hughes. I have been authorized to practice law since 2016. I am employed with Luter, Larkin, and Hunter. The attorney fee and billing statement that I emailed to Mr. Freehoff is made in the regular course of our business. Based on my knowledge of the case and my experience in this field, which is about 5 years now, I believe they're reasonable. The fees include filing this case, service costs. It took us quite a few chances to serve Ms. Lodge. The total fees are $3,228.50, and the costs are $529.50. That includes 2 sets of service attempts, the filing of the lawsuit, and recording a notice of lien. The fees are all inclusive of my time here today and filing all of the pleadings in this case.
Okay. Thank you very much, Ms. Hughes. As I noted a moment ago, it does appear that the defendant Lodge is in default, having not answered the complaint, and more than 15 days having passed since that person entered default. Therefore, the plaintiff would be entitled to a default judgment subject to proof of the unliquidated damages, which you have just provided me. And so the order that you sent over, I believe I understand and agree with you that your client would be entitled to a total money judgment in the amount of $7,043.22. And that the order will include a right to foreclose a statutory lien in the amount of the money judgment, and then an authorization to foreclose the statutory lien, and then the additional relief sought in terms of the priority position that the plaintiff retains in the event that there is a foreclosure sale, et cetera. And so all of that seemed to be in order, and I'm happy to go ahead and sign off on the proposed order that you sent in those amounts. Anything else you want me to address, Ms. Hughes?
No, thank you, Your Honor. May we be excused?
Yes, thank you both. Nice to
Have
meet
a
you,
great
Ms. Lee.
day. Thank you.
Okay, and then next I have, hi, Ms. Burnett.
Good morning, Your Honor.
Good morning, and Ms. Roberts. Okay, so let me pull up the Cascade Cove. Okay, so this one is also one, as I mentioned a moment ago, Ms. Roberts. So I've reviewed the file. And I wanted to make sure that you were aware that, and Ms. Roberts, I'm educating you as well, that my record indicates that service was made on December the 16th of 2024. And that means, Ms. Roberts, that you had until January the 15th to file an answer, and you did not. Now, beyond that, Georgia law provides that once you are in default, which you are in default when you don't file an answer on or before the 30th day after service, that you can open default by paying costs and filing an answer within 15 days. And today is the 15th day. And so I don't know the extent to which any action has been undertaken to open that default. But I wanted to talk a little bit with Ms. Burnett first, and then I'll hear from you, Ms. Roberts. Ms. Burnett, so as I said, I've reviewed the file and it does appear that Ms. Roberts is in default, but that Cascade Cove wouldn't be entitled to a default judgment unless and until we get to tomorrow and no one has opened the default. In the event that default were opened, then of course you would not be entitled to a default judgment. However, I think it would be helpful for everyone, unless you have an update from me regarding communications with Ms. Roberts or some other resolution that we might have today, for you to walk me through. What I am aware of in your case is that the liquidated amounts that were sought in the complaint in terms of assessments and utilities owed to the association are $13,420 in principal, $2,273.07 in utilities, and interest in the amount of $1,819.83, which is typically, for Ms. Roberts' benefit, that interest is typically included in the declaration or association documents. And then the association documents also typically provide the recovery of attorney's fees for efforts to collect those association costs. And that's where I'll throw it over to you, Ms. Burnett. I have the number here of attorney's fees that you're seeking in the amount of $2,425.15. But to the extent that you need to provide me with evidence or testimony regarding the amount of those fees and when and how they were incurred. And before you even go to that trouble, if there's some update or information that you need to provide me regarding any communications that y'all have with Ms. Roberts, or if it would be helpful to place you guys into a breakout room and see if there is some communication or resolution that the parties might come to, I can do that as well. Ms. Burnett?
Thank you, Your Honor. So actually, there was a mistake in my motion that I submitted to the court. My paralegal sent over a revised proposed order for Your Honor. We're actually seeking $1,892.52 in attorney's fees. And in support of that, I will state the following.
I'm sorry, forgive me, Ms. Burnett. Can you give me that number again?
$1,892.52.
Thank you. Go ahead.
I am admitted to practice under the laws of the state of Georgia. I have been practicing for 7 years, since 2017. I'm currently affiliated with the law firm of Pankey and Horlock, where we practice primarily in the area of community associations. My hourly rate is $250 an hour. My paralegal's rate is $125 an hour. And I also work under a of counsel of the firm whose rate is $300 an hour. Over the life of this case, we've spent about 7 hours on this matter, which we deem to be the cost of collecting the unpaid assessments. All expenses and fees were reasonable and necessary to collect on this judgment. There is a statement of fees and expenses attached to our motion, which was filed on Monday, the 27th. We've also included with our motion an affidavit of the property manager who verifies that the amounts owed are correct. And just as a summary of some of the work we've done on this case, we have sent to Ms. Roberts 3 demand letters. We've drafted, filed, and served the complaint. We've drafted and filed the motion, which is before your honor today. And we've also expended some administrative costs, including the cost of mailing those demand letters, and of course, the court costs, which include the filing fees for this action.
Okay, thank you. So just to be clear, Ms. Burnett, the total amount of the judgment that you're now seeking based on that reduced amount of attorney's fees would be $19,405.52. Is that correct?
I have $19,405.42.
And the attorney's fees you sought were $1,892.52?
Yes.
Okay, well, I am not good at math. So what I did was copied and pasted those numbers into Excel, and Excel says that the total sum of that amount is $19,405.52. I'm sorry, 42 cents. Is that the right number?
Yes, that's the number.
Okay. Okay. So apparently I'm not only not good at math, I'm also not good at Excel. In any event, I think it was a typo, but it is nonetheless fixed. Okay. So with that, Ms. Roberts, if you want to unmute, you're not required to say anything, but I did want to give you an opportunity to address the court. I want to make you aware of a couple of things. So as you heard me say, technically you have today is the 15th day. And so if you were, I cannot give you legal advice. I cannot tell you how to do anything. But technically, if you were to appropriately pay costs and undertake the other steps that are necessary to open default, then you could potentially open default and file an answer. And a judgment would not be entered against you today. So I want to make sure you're aware of that, number one. Number two, however, is that to the extent you are in default because you did not file an answer on or before January the 14th or 15th, what typically happens is that means that the allegation that you owe the assessments and that the assessment amounts that are alleged are correct, those things are admitted because you didn't answer and say that's not correct. And so I want to make you aware of that because what we're really talking about today is the extent to which the dollar amounts are correct in some way. And if you want to educate me about that, then this would be your opportunity to address the court. So please go ahead, Ms. Roberts.
Thank you. I called on the 28th because I was, excuse me, sick. I called on the 28th because I wasn't originally served papers. I had a babysitter at the time and they got the served papers and set them to a side. When I researched, because I received a letter in the mail about court today, I called the attorney's office and asked, could we set up a payment plan and move forward with that? I don't know if they were willing to set up a payment plan with me on the 28th, because I don't know if I called too late, but I was telling them that I wasn't able to read through the document, so I did not understand what rights were afforded to me in this matter, and if we could talk about a payment plan. They were talking about a 40% payment, but that's as far as we got. That they were, I guess I was too late to file whatever motion to stop the proceedings in place.
Right. And again, I can't give you legal advice, and certainly Ms. Burnett or anyone on behalf of her firm, they can't give you legal advice either. But when you were talking to them on the 28th, the deadline, it's unfortunate that your babysitter did not provide you with those very important papers. But typically what happens is once the deadline has come and gone, then you are past the point of being able to assert defenses. That doesn't mean, in my experience, whether there's a judgment or not a judgment entered. In my experience, the law firms are typically, because the associations want to get their money, they typically are willing to enter into a payment plan. Ms. Burnett, is that something that you're authorized to discuss? And would it be helpful to have maybe you and Ms. Roberts speak maybe in a breakout room for a few minutes to see what might be accomplished?
That's fine with me, Your Honor. I am authorized to enter into payment plans. I can negotiate the payment plan, but obviously the board of directors has the final say on what the terms would be.
Understood. Ms. Roberts, would it be helpful if I could put you guys in a breakout room and let y'all talk directly for a few minutes, okay?
Yes, ma'am. Thank you.
Okay, so Mr. Freehoff is going to create that breakout room, and I think it means you'll get like a note on your screen that says, do you want to go to the breakout room? And you have to hit yes or something. So, Mr. Freehoff, if you'll do that, please. Okay, and Ms. Spells, I see that you are on the call. Nope, she went to the breakout room.
Judge, let me try and get her back.
Mitch, I'm going to get more coffee while you do that.
Am I here? Thank you.
Yes, you're here, so sit tight until the judge returns.
Okay, thank you. I'm sorry.
Hello, thank you for your patience. I was grabbing some more coffee while we were rearranging everybody.
Hi.
Ms. Spells, I see that you are on the Zoom now. Want to make sure you are aware that the hearing was actually scheduled for 9 o'clock and that counsel for Greatwood Glen already appeared this morning, and I entered the judgment that they requested because you were not here. I mean, to be clear, as you and I had discussed, legally they were entitled to the last time. I didn't want to talk with you too much about the substance. But legally they were entitled to the relief that they had requested. But in addition to that, you were not present for the hearing. Excuse me. And so I do want to let you know, I did receive, as I communicated with the lawyers for Greatwood Glen, I received the paperwork that you sent over about the payment that you had made. And my understanding is that they acknowledged that that payment was made, but that it was made to a different association for a different matter, unrelated to the debt that is owed in this case, and that was sought to be recovered by Greatwood Glen. And so my review of the record indicates that that is at least facially, it does at least facially seem to be accurate, because it was paid to a different law firm than the law firm that represents Greatwood Glen in this case. And so ultimately the judgment that was entered was the one that was requested, that you had received a proposed judgment, because you've sent it to me a couple of times in the paperwork that you submitted to the court. I understand how upsetting that must be. And I understand that you don't agree with that outcome. But I wanted to make you aware of that before, if there's anything you wanted to speak with me about, I wanted to make you aware that I received your information, and that even though you were not here, I did question counsel and Greatwood Glen about that issue and received answers that appeared to me to be accurate and satisfactory to resolve the issue. Ms. Spells?
Yes, ma'am.
Anything else that you want?
Yes, I'm sorry, Your Honor. I was here last week with the understanding of trying to be able to settle this. And for some reason I was taken off the docket and didn't know. And I waited until yesterday when I sent information to Mr. Freehouse. And he addressed it this morning, saying, yes, I had to be here this morning. I couldn't find the Zoom information. I even have screenshots of the technical problems and things that I had. I tried to contact Noack Howard. They've been so unfair. They either don't answer the call, they don't answer your messages, maybe once or twice. The paralegal, he said, if you paid the $4,800 in cash, would you need to do installments? I said, no, I'll pay it right now. And so that's what I'm thinking. And I haven't heard anything back from him, thinking that I was hearing from him. I saw the Sierra Coulter thing and asked Jennifer, who runs the CMA over here. And she says, well, maybe it's another attorney's office, but that's all that I had. And I'm thinking that that's the $4,800 that I originally, back in October, was starting. They wouldn't answer until finally the $4,800 went to $7,000 because the cycle had gone up. And I said, I am under major hardship right now. And so I'm trying to negotiate a payment plan from $5,000. You guys go up to $7,000. And now all of a sudden it's $89,000 when I'm thinking that I'm paying $47,000, that they had decided to be reasonable because I said that I finally managed to get the cash to pay. How can it be doubled? I'm sorry. I've been trying to reach them. Then they don't contact you back. They said, we'll try the owners at whatever, and they don't get back to you until it's all of a sudden $2,000 more. How's it going to go up double when I'm trying to negotiate a payment plan to go down? They didn't accept the first one, and I didn't even know that they hadn't accepted the first one.
Ms. Spells,
I'm sorry.
No.
I'm sorry. I just don't have $9,000.
Ms.
And I just gave away $4,000.
Let me tell you this. Okay. So first of all, I'm very sorry that I am the person who is in the position to enter an order that is so, it's going to be so difficult for you to deal with. I apologize. It is one of the least pleasant and most difficult parts of my job. Let me tell you, however, that the information that I have been provided is that there are two separate matters where two separate associations are attempting to recover amounts that they claim you owe to them, and that they are represented by two separate law firms, and that the payment that you made that you believed would resolve one of that claim was to the other law firm and potentially did resolve that claim. I don't know, because the only information I have about it is that it is a separate claim, and that that law firm that you made that payment to is the one who represents the Master Homeowners Association in that claim. Also understand, Ms. Spells, you are not the only person who appears before me, no offense to Ms. Burnett, and complains that lawyers at these types of firms who do this kind of work are not particularly responsive and do not return phone calls when you are attempting to resolve the case. I understand your frustration. Unfortunately, legally, the association has provided me with the information that is necessary to obtain the judgment that they sought. And so I have entered the judgment. The only thing I can tell you, and I know it's frustrating because, again, I understand that it is difficult to get these law firms on the phone. The only thing I can tell you is that in my experience, their preference is always still to try to get a payment plan, even once they have a judgment, to try and work out a payment plan so that this matter can be resolved at some point. And beyond that, again, Ms. Spells, my apologies that you were having such a rough time and that I am the person who has to be the bearer of that bad news. But that is legally what has occurred today. And your next steps would be, either to pursue some sort of appeal if that's what you choose to do, and or to stay in touch with the attorney's office who obtained this judgment on behalf of Greatwood Glen. Do you understand, Ms. Spells?
The attorneys, the last part, I'm definitely not understand. Well, can it be because I was before 9 a.m. trying to reach and trying to get online, and even the information that I sent, I even asked Mr. Priop if he could give it to you on my behalf, because I was there and was trying and have been since before 9, and even last week, that it could be continued or something, since I had to wait. And I was hoping maybe even if I was the last person, but since I wasn't there to be held till the end because I was trying so hard, I have $1,700 in the bank.
I understand, Ms. Spells, and I apologize. Unfortunately, I have other attorneys and other matters that I need to address. There are steps that you can take that I've outlined for you today. If you are unsatisfied with the ruling that I've made today, that is absolutely your right to, ask a court to revisit it. I also encourage you to continue to follow up with that law firm to see what can be resolved, because there typically is a way to do that. But for now, I am going to have to adjourn this matter and wish you the best of luck and hope that you have a good day going forward. I'm, again, very sorry, Ms. Spells.
Thank you. Thank you
you.
very much.
Have a good day.
I can't now, but thank you.
Ms. Burnett and Ms. Roberts. So thank you for taking the time. Ms. Roberts, are you there? Sorry.
Yes, ma'am, I'm here.
I thank you for taking the time to talk and see what might be accomplished in this matter. Can you tell me if anything has been worked out, or what is the action, that the action that the parties want the court to take? Ms. Burnett.
So we have reached an agreement.
Okay.
Ms. Roberts is going to pay 40% of her balance as a down payment. That'll be due on February 7th. And then for the remaining 7 months in the year going into January 2026, she will pay an amount of, I said 7, I meant for the next 11 months, she will be paying $1,475.30 each month to be due on the 7th. I told her I would submit this to the board for approval, and if they approve it, I think they will. I'll submit a consent order for Ms. Roberts' signature and then for your honor's signature.
Perfect, thank you. My only request, I know there's time that's built into drafting that and then to getting your client's approval for it and then to getting Ms. Roberts' signature. But ideally, I believe we typically have another default calendar sometime in the middle of every month. We typically have one at the beginning of the month and then middle towards the end of the month. And so what I'm planning to do probably is have Mr. Freehoff place this on whatever our mid to late February calendar is. And of course, y'all wouldn't need to appear if you go ahead and get the consent order signed and submit it to the court. And if that hasn't been done, then y'all can appear and we'll discuss, what steps to take. But of course, I fully expect that y'all will be able to accomplish that.
Okay.
Ms. Roberts, is that your understanding of the resolution that y'all have worked out?
Yes, ma'am. And thank you for the opportunity to go into the breakout room. Thank you.
Excellent. Well, I'm glad and I appreciate you both taking that opportunity and using it apparently quite productively. Ms. Burnett, then what I will look for, as I said, you will receive another notice from us for this matter to be on a calendar. But again, once we ensure, if y'all just send us the consent order, you will not be required to appear for that hearing. We'll get it on file and this matter will be closed. Okay? Thank you both. Have a great day.
Thank you, Judge.